Antonio Capobianco. I'm the acting head of the competition division, and I welcome you to this first session of the day, the keynote panel on competition in the digital age. As you've heard already from the excellent opening remarks from Margarita, digitalization has profoundly reshaped our lives, first of all, but also our economies, and has therefore been occupying an increasing share of the competition authority's attention in recent years. Academic research has identified concerns ranging from market power of digital giants, killer acquisition of nascent competitors, vertical issues in e-commerce, monopoly power of platforms, algorithmic collusion, which was mentioned by Margarita. In response to these concerns, competition policy community, including, of course, the OECD Competition Committee, has emphasized the continuing relevance of core competition enforcement principles. It identified some adaptation to analytical tools and highlighted the need to draw a line between issues within the realm of competition enforcement and those more appropriately addressed elsewhere: privacy, data protection, consumer protection. Now, the focus has moved from theoretical discussion in many jurisdictions has moved towards the identification of concrete changes, concrete measures that governments and competition authorities should adopt to the policy framework to address those concerns brought up by digitalization. Expert reports, sector inquiries, public hearings have reviewed proposals in many jurisdictions. I mentioned some: Australia, Canada, the European Union, France, Germany, Italy, Portugal, the UK, the US. So many governments and many institutions have been part of these debates. Now, these proposals range from a more aggressive enforcement under existing competition law frameworks to legislative changes to the competition framework to the creation of entirely new regulatory framework. Thus, digital competition enforcement issues and potential adaptation of competition policy remains at the forefront of the debate. And competition authorities are now being asked to assess and respond to these new proposals and may in the future need to adopt legislative or institutional changes stemming from these proposals. At the same time, they will need to continue to remain abreast of development in the digital markets and ensure sufficient technical expertise in order to tackle complex economic issues and potentially detect novel forms of digital misconduct. Hence, the reason of today's panel, outstanding panel of experts, I would say. They have all played a key role in this debate, and we have invited them here today to discuss with you basically one question: what is the future of competition and competition policy in the digital age? Now, you see here three panelists, but the panel is a little bit broader than that because we have 4 virtual panelists that you will see on screen. They are all heads of authorities, and to which we have asked questions, 3 questions that will guide also the discussion of the panel today. These questions are: what are the biggest challenges that the agency faced regarding competition enforcement in the digital economy? What would they change in the current enforcement legal framework? What tools they would need to address those concerns? And then beyond enforcement, competition enforcement, should there be regulation or more regulation, and what kind of regulation? So those virtual panelists, I'll list them according to the OECD tradition, according to their jurisdiction in the French version. So l'Allemagne, so we'll have Andreas Mundt, the president of the Bundeskartellamt in Germany. L'Australie, Rod Sims, the chair of the ACCC, the Australian Competition and Consumer Commission. And then there's the États-Unis, so the United States. We'll have the chair of the 2 agencies, Joseph Simmons, the chairman of the US Federal Trade Commission, and Megan Delrahim, the Assistant Attorney General at the Antitrust Division of the US Department of Justice. We'll ask them the question, we'll play 3 times videos, and then we'll use that to kick off the discussion with our panelists here. And I don't need to introduce them, but I'll say a few words. I'll start with Amelia Fletcher. She's, I would say, a true rock star and a professor of economics. She is the Competition Policy and Center for Competition Policy at Norwich Business Schools at the University of East Anglia. She was also chief economist at the UFT, very well-known economist and thinker on competition policy issues. We have Jacques Crémer, professor of economics at the Toulouse School of Economics and director of the Digital Center since 2015. He was appointed special advisor to Commissioner Vestager and one of the authors of the report, the special advisor report on competition policy for the digital era. Was already mentioned that Amelia is one of the co-authors of the Furman report, Unlocking Digital Competition report of the Digital Competition Expert Panel. Last but not least, on my right, Doug Melamed. Doug is a professor of law at Stanford, but he has a long-standing career in private practice with Wilmer Hale. He was also senior vice president and general counsel of Intel. And he also had an experience in government. He spent some time, several years at the U.S. Department of Justice, where he, among other functions, he also was acting assistant attorney general in charge of the Antitrust Division. And then there is another sort of participant to this debate, and this is you. As I said, we have offered an opportunity for you to participate. We have, through the app, there will be a QR code that will appear regularly through the discussion on the big screens behind us. We have a question for you, and you can answer now. You can answer throughout the panel discussion, and we'll show the results at the end. And I think the question which is coming up on screen now is the question that we will basically be discussing this panel. That is the future of competition policy in digital age, and in particular the role that enforcement and pro-competitive regulation may play in shaping the future in digital markets. And the three possible answers are, if I can get them, do you think there should be a more vigorous enforcement of competition law in digital markets? That's the first possible answer. The second is government should take a more active regulatory approach to addressing concerns from digitalization. Or the last option is government should not intervene, but rather let the market force shape the future competition in digital markets. So what are your views? Maybe your views will evolve once you have heard the panelists, the discussion. So we'll look at the results at the end, and maybe we'll ask our panelists here to comment and react to those results. So let me start now with the panel, and I'll give them a few minutes each to each of our panelists here for some opening remarks. You have a carte blanche. You can make your own opening statement, and then we'll go back to the three main questions for the panel. We will start with Professor Crémer on the left. Thank you.
Thank you very much. It's nice to be in a good international organization where they know how to put the right accent on my name. Now we've been given about 6 minutes, and I want to make 3 big points. So I'll try to be fast. I won't go into specifics because we've got very nice videos later to introduce the discussion of specific points, but I want to make a few general statements. Actually, there could be only one, because my first point is that we shouldn't overestimate the importance of competition law, and I might be kicked out of this panel after I've said this. But the second one, I really want to stress that the digital age is different, and that we face different problems than we did with other types of technical progress. And the third point is that I like to make is that we need to keep things simple in terms of enforcement and fast. And I think I'll try to speak a little bit about this. So, first point, don't overestimate competition law. And I've promised myself that for the next 6 months, every time I speak in front of an audience in which there's a good proportion of Europeans, I would make this point. I'm a little bit worried that Europe is beginning to feel very much like wanting to control tech. We've got huge amount of discussion. How do we go about controlling big tech? And that's not our main. I mean, there's a problem of controlling big tech. That's the field in which I'm the less incompetent, so I'm happy to speak about it. But I don't think that's the main problem of Europe in terms of technology. Our problem is a lack of innovation. And we should really be focusing much more on what should we do in terms of increasing European innovation rather than what should we do in terms of controlling technology. And this is a much, much more difficult problem. It's politically very difficult to tackle, but I do hope that we get also big conferences which are centered around that topic. And it's especially important for those of us who are staying in the EU because it's clear that Britain was a big part of innovation in Europe, and so we've got to do this. Second thing, is the digital world different? So very often when I speak to people, they tell me, oh, well, we've had lots of technological, very, very big technological changes. Electricity, cars, telephones, radio, fundamentally change the way society works. Okay? On the other hand, I think there's a difference, is that they change the world by changing the way we do a few circumcised thing. For instance, cars, was very important. They change our towns. They change the way our countryside looks. They change the way we entertain ourselves. We can go to a movie which is far away from our house, and so on. But they did this by just changing the way we transported ourselves. There's something different about the digital age, if you think about it, is that it's a very integrating force. Digitalization doesn't touch only one thing, it's kind of integrating the whole world. So for instance, telephony improved communication, and we've seen over the last, from the time of my youth to today, which is beginning to be a long time, the cost of telecommunication has decreased considerably, but if I just think about the telephone, it's always the same thing, just done easier. If you think about the digital world, it means that, as Margarita pointed out, all the data is centralized. The data on what you're consuming and the data of the firm which is producing what you're consuming can be centralized. And all those things are all linked together in ways which none of the other technologies did the same thing. So I think it's very important difference. And I think if we mess up on the way in which we manage this technology, it's going to be very, very costly. Third point is we really need to keep things simple and fast. And maybe I'll pick up on one point that Margarita was speaking about, which was, is this a consumer protection problem, or is it a competition problem? Lots of things are at the margin. Very often it's much easier to use competition law, to use consumer protection law than using competition law. In this case, we should use consumer protection law just because it's fast. We've got to remember, we don't really understand how competition works in the digital world. It's a very, very complicated system. And by trying to over-optimize, I think we can do much more harm than having simple rules around which people can optimize. And I hope we'll get back to this topic. Okay, so 3 messages. A, think also about innovation. 2, this is really a different type of world, and we really have to use new thinking. 3, don't make things too complicated. Thank you very much.
Merci. Amelia.
Thank you. So because we were invited here, I think because of the respective reports we've been involved with, I thought I'd better actually describe in my introductory report some of what we came up with in the UK report, often known the Furman report, so a slightly different approach to Jacques. Our report was commissioned by the UK government and actually published almost a year ago now. A lot has developed since then, and this is, I think, probably the biggest room I've been in with the most senior set of people to discuss it, but a lot of talking has been done. We were very clear in our report that digital platforms have brought huge innovation and huge benefits, but that we did see a number of markets which had tipped to being highly concentrated, where that market power either has been or risked being extended into related markets, and indeed the building of ecosystems of a variety of markets. And that this was seemingly long-term, while we thought that there was potential for market positions to be undermined through a creative destruction of new innovation. We didn't think that that was, we could rely on that occurring to solve the problems in these markets. And we thought all of that created a serious risk of consumer harm, partly today, but actually even more for the future. So we made some specific recommendations on mergers and antitrust, for example, to speed up processes around interim measures, to increase the focus on digital mergers, and potentially to change the UK merger test itself. But our centrepiece recommendation was to introduce ex-ante regulation via a digital markets unit. So it goes directly to the question that you've been asked to respond to in your survey today. When we made that recommendation, we didn't mean kind of old-fashioned utility-type price regulation, which clearly isn't what we want here, but a much more competition-focused form of regulation, reflecting the fact that I hope everyone in this room would agree that competition generally is better than regulation, but that it may need really proactive support in order for that competition to be effective. The UK government is committed to taking forward thinking on this, but there's been nothing firm yet. But I do want to just advertise that the CMA has published its interim report on its market study into digital advertising, which is really interesting in many, many ways, but does, as part of that, provide some thoughts on how ex-ante regulation might be framed in those particular markets. Why did we think ex-ante regulation was important? We did think that ex-post competition law continued to have a really important role to play, but there were two real reasons. First, that actually some of the drivers of what is happening in digital markets are inherent in the economics of those markets. So network effects, economies of scale and scope, the incredibly important role of data and the agglomeration of data, and the importance of that as an input to a provision of lots of the services. We heard about algorithms from Margarita earlier, which lie at the heart of many of these services. Also the consumer biases that we heard about earlier. While all of those have been present in markets in the past, we felt that the confluence of them and the strength of them in digital made digital really different from things we'd seen in the past in terms of the economics. And that means those jointly mean that we're very likely to see tipping in markets and indeed leverage of market power from market to market, even without any kind of strategic firm behaviour that we might normally consider a contravention of antitrust law. And that means that we didn't think that kind of penalising firms for behaving in what they might consider as a completely normal and efficient and profit-maximising way was necessarily the best way to achieve a more pro-competitive outcome, rather that you need to be more proactive in thinking about the way in which markets should be designed and the framework within which firms should act. The second and more maybe parochial point is we felt that ex-post enforcement takes an awfully long time, tends to be backward-looking more than forward-looking, tends, by the time you've got to the end of a case, to be relatively narrowly focused, and therefore not ideal for setting the kind of wide range, overarching, effective, forward-looking framework that we really need in these complex and highly tippable markets. So we came out with our recommendation, which was to set up this digital markets unit that would have 3 objectives, and I will go quickly. The first is that the regulator would designate certain platforms as having strategic market status. And for those platforms, there would be a code of conduct. It would be different for each platform and in each market, but because they have rather different services and rather different issues, but that all of those codes would be based on some overarching core principles that we thought could be the same across all digital markets, because in the end, there's also a lot of similarity across the issues we see. We thought it was really important to have participative development of the codes of conduct with all stakeholders, and that they should remain flexible as markets change over time and new issues arise and become understood. So that was one set of things. The second objective was around promoting data mobility, interoperability, and open standards. And that was about really facilitating greater switching by consumers, but very importantly, more multi-homing by users. And the idea of multi-homing is if you have more multi-homing, then markets are less likely to tip to monopoly. Likewise, if you have more interoperability, markets are less likely to tip to monopoly. So we felt that was really important in terms of creating appropriate market design to allow multiple players to remain in markets. And finally, we thought the regulator should have an objective of data openness. The idea here is we know this data that is held by digital platforms is incredibly important for developing new services. And therefore, we thought that in certain situations, new providers or competing providers should be given access to that data for use cases where that was needed in order to develop new and innovative services, obviously protecting privacy in the meantime. So I hope that gives you, I hope within time, a whistle-stop tour.
Thank you, Amelia. Doug, so you've heard the Europeans. What are the views from the other side of the Atlantic?
Well, it's probably not an accident that I'm sitting to your right. You know, outside this room, the digital platforms are certainly creating a great deal of unease. It seems to me that there are perhaps 3 factors in principle that are in particular that are driving that. One is the seemingly boundless network scale and scope economies of these digital platforms, unlike maybe the steel monopolies of generations ago, which not only have the specter of an enduring dominance, but extension of the dominance into adjacent markets. Technology, a kind of technology black box. People don't understand it. They're intimidated by it, particularly when you get into matters of artificial intelligence and machine learning. And then finally, the fact that the digital platforms implicate not just economic competition, but other important values, privacy, kind of a reestablish, a breakdown and recreation of community and speech. The last, I think, in particular, should be a cautionary note, at least from across the pond, because one could look at U.S. competition law history and find an excessive, overzealous application of antitrust law to the then dominant communications medium, motion pictures in the 30s and 40s, broadcast television in the 50s and 60s, cable in the 80s and 90s, and arguably a push now in the internet area. But notwithstanding all this, it seems to me that the expert agencies, these the reports that we in effect represent today, have at least implicitly not departed from the basic normative framework of competition law as we've come to understand it in recent decades, which is that it is about protecting competition in order to promote economic welfare, and that it is a law of proscription that proscribes anti-competitive conduct that has the effect of creating market power and thereby injuring competition. But given the concerns about the new challenges posed by the digital platforms, there also seems to be, in varying degrees, a kind of consensus that the particular application of that normative framework perhaps needs to be adjusted at the margin, recalibrating the relative risk tolerance for type 1 and type 2 errors, addressing issues of nascent competitors, acquisitions of nascent competitors, and the issue of making competition decisions under uncertainty and the like. But I think there are some hard questions that go beyond that that are raised by three factors that have been alluded to, and particularly by Margarita in her excellent speech. One is data, which is seen, I think, not without reason, as giving the incumbent platforms perhaps an almost insuperable barrier to competition, because it gives them the capacity to offer their trading partners, particularly on the advertiser-supported side, benefits not available to others. The other is artificial intelligence, and more than that, more I think than the kinds of algorithms Margarita was talking about, is machine learning, which makes understanding after the fact what happened, or predicting beforehand what will happen, a much more daunting challenge than competition authorities have typically faced. And the third is the manipulation by the digital platforms of behavioral biases that are coming to be understood in the behavioral economics literature. And so the question that these three factors raise, in my mind, and I think again implicitly in the three reports, is whether they justify or warrant some kind of sector-specific rules, substantive rules. For example, again, looking at it from the perspective of the United States, we have a very high barrier to imposing a duty of a firm to deal with its competitors. One might suggest that where data is so critical to competition, that bar ought to be lowered a bit to give competitors paying appropriate compensation access to data that's been assembled by the incumbent firm so as to lower an entry barrier. And there are other kinds of sector-specific rules that one can imagine. But the really hard question, and I think it's one where, as Amelia said, perhaps the UK report is out in front of the others, is the question of whether this sector-specific rules, if any, should go beyond proscriptive rules that identify conduct that is anti-competitive and warrants antitrust intervention, and include prescriptive regulation, do's and don'ts, code of conduct, to use the term in the Furman report, and the like. Now, it's easy to imagine a regulatory scheme, a code of conduct, a set of prescriptive rules that make sense theoretically. It's much harder to implement them and to keep them current. And the danger, as we all know, is if we go in the direction of prescriptive regulation, we're going in the direction of supplanting marketplace competition, not to be sure with power, private power exercised by dominant firms, but with government power in the form of regulation. And that would seem potentially to undermine the very purpose of competition law, which is to reflect the premise and the judgment that economic welfare is best served by competition, not by a kind of command, whether it be private or public, a command economy. So to me, that's the real question that we should be discussing today. It's a more important question, I think, than whether you have a sectoral regulatory agency, which might be appropriate if there are sector-specific rules. But it's the question of do you cross that line between proscriptive intervention and prescriptive intervention?
Thank you very much, Doug and Amelia and Professor Crémer. I think we've put a lot of questions on the table. I can guarantee you we will not be able to address them all in the next hour, but we identified a few areas for discussion here. And maybe this is the right time to bring in our sort of virtual panelists. As I mentioned before, we asked 4 heads of agency 3 questions that we'll then bring back into the room. The first question, and I think all of you have sort of started from there, so the challenges. What are the challenges? What is the biggest challenge facing your agency regarding competition enforcement in the digital economy? So we can play a video. They had 1 minute each to answer this question, and we'll bring then the discussion back in the room.
Well, the biggest challenges for our work in the digital economy, the first one is we see sometimes small actions by large players that have a significant impact on the market. That means we need swift and timely interventions by competition agencies, but we have a natural tension between timely intervention on the one side, between speed, and thorough legal and economic assessment on the other side. So we need to strike the right balance here, especially when we deal with fast-moving targets due to technological developments. The second issue, we are doing work on highly concentrated markets, so our only sword is abuse control, and you all know that abuse control is the Mount Everest of competition law, but we have to apply it on a daily basis. And the third one is that we have legal frameworks that in many cases are not adapted to these new business models that are purely data-driven. We must get our cases through the court, and we have just seen in a Facebook case that our court at least took quite a narrow interpretation of the existing legal framework. So I think these are challenges that we all have to deal with.
I think the biggest challenge is the complexity, the opaqueness of these digital platforms combined with their size and influence in particular markets. So various markets are hard to understand, like the ad tech market. Their ability to self-preference is hard to detect, and this can have very powerful effects in other markets. Of course, I also have to mention their acquisitions, numerous acquisitions, certainly buying out potential competitors, but at a time when it's really hard to tell whether those firms are going to be potential competitors. And if I could just mention one more, the problem is it's hard for new players to get in the market when you've got take it or leave it provisions around data, which the digital platforms usually have. So you've got this complex intersection between competition and consumer law, which I think has to be taken into account.
The biggest challenge facing U.S. competition enforcement in the digital economy is that it can be difficult to detect when a course of proposed action constitutes over-enforcement or under-enforcement of our laws. Moreover, it can be challenging to establish the degree to which either trend might be taking place. As I think about the U.S. antitrust enforcement in the digital economy, I keep steadily before my mind that false negatives and false positives each carry their own harms to the future of innovation, quality, and consumer choice. Some monopolies, left unchecked, will swallow their ecosystems, and history will judge us harshly if we do not take appropriate action to stop them. Nonetheless, we cannot break the kinds of incentives to innovate that have spurred advancements in telecommunications, defense systems, healthcare, and other important parts of the digital economy that have benefited the world over.
I believe that our biggest challenge lies in ensuring sound, economics-based antitrust policy and enforcement at a time when some of the fundamental principles and approaches of antitrust law and policy are being challenged. Many of us are facing pressure to extend competition policy and enforcement to encompass non-competition and sometimes political objectives, including in the digital sector. I am concerned that such approaches could weaken the coherence and even the legitimacy of our missions, impacting the achievement of our agency's goals and our ability to effectively promote competitive markets. The FTC recently conducted a series of hearings on competition and consumer protection in the 21st century as a step toward reestablishing a consensus on how to do effective antitrust policy and enforcement. We made sure to hear from proponents and critics of the current system so we can take into account concerns from people representing a wide range of viewpoints. We are also interested in hearing about the approaches you have taken to address these important issues.
So you've heard from these four heads of agency, and I've sort of picked a few keywords or words, concerns, large players, a need for timely interventions in fast-moving markets, high degree of concentration in some of these markets, the complexity of the digital markets, the digital economy, risk with over-enforcement or under-enforcement and the impact on incentives of firms, the goals of competition, what are competition policies supposed to protect, what is the role of competition authority in that. Now, all of you have sort of worked on reports for governments, or some of these governments. The starting point is, of course, identifying what the problem is. Do you agree with them? Do you think there are other challenges? Maybe I can start with you, Amelia, and then ask the others.
So I do agree with a lot of the comments that were made. I agree in particular that with Andreas Muntz that a key problem is balancing the need for thorough analysis with and for due process with the need for timely action. Obviously, timeliness is really crucial because once markets have tipped, if they're inclined to tip, then it can be incredibly hard to untip them again. Equally, though, it seems unfair to impose massive penalties on firms without doing a very thorough analysis. So I fully agree with that concern. The question I then have is, can we solve that through faster competition law, or is that part of the argument for regulation? Which of those two ways of dealing with issues can be the quickest and most flexible? I also agree with the Department of Justice, Makim Delrahim, that it's important to consider the risks of over-enforcement as well as under-enforcement, including around the risks to innovation in particular. And it is true that the potential to sell out to a big digital platform, for example, is a key factor in enabling small startup digital tech companies to gain access to venture capital. That's a kind of really established line where you basically you get money because the end game is selling out for a lot of money to a big tech platform. That is, in turn, that desire to keep that in place and promote that sort of innovation was one of the reasons the Furman panel itself didn't propose reversing the burden of proof for merger control, although quite a lot of people had been arguing that that was a sensible approach. That said, in terms of this over-enforcement, under-enforcement, where the Furman report, and I think we still are, came out, is that the risk of under-enforcement in this space seems far greater than the risk of over-enforcement. They're really, in particular in the area of mergers, there's been incredibly little intervention. So we did recommend a substantial reset, in particular in the mergers area, to push towards, push away anyway from too little intervention. Some of the additions, a couple of additions that I would make in terms of challenges. Not only are these complex and novel markets, but the theories of harm that you might end up looking involve complex and novel economics, which is also inherently very difficult to evidence. We just heard about machine learning. That is on its own very difficult. The economics on top of that is even more difficult. This means, in turn, it can be really hard to reach the required burden to bring successful antitrust and mergers cases, and may take a lot of time to do that. That's one of the reasons why I think we end up with under-enforcement. The Furman review did recommend a change to the mergers test to try and help address that and move away from under-enforcement, but I do think there are that it's not the only solution. That's the one challenge. The second challenge is the one that I made earlier, which is that some of the harm here may not actually involve strategic anti-competitive behaviour by dominant firms. If we think about the point about interoperability, actually you want to have, so if we think about mobile phones, we can have many mobile phone networks in a country because I can ring someone on a different network from my phone. We have that interoperability, therefore we don't have a market that tips to monopoly. If we didn't have the interoperability, we would get a market that tipped to monopoly, but you want to put that interoperability, you want to design that market framework before you ever see the dominance, and therefore abusive dominance law cannot be the right way of achieving that end.
Doug, maybe I ask you, so you heard the heads of the two US agencies flagging some of the concerns they have, or that they're facing, their agencies facing. This came up of the debate and the hearings in the US?
Well, let me say, I certainly agree with Joe Simons about the need for an economically sound enforcement, not compromised by other objectives or other values. That's a big debate, of course, in the United States now with the sort of populist New Brandeis movement. Those other values, wealth equality, power equality, and the like, are not unimportant, but they're not suitable for sound competition law enforcement. But that takes us to a problem that is addressed, I think, in different ways by the three other officials that we just heard from, which is the problem of uncertainty in competition law enforcement. It's inevitable in general, I think, in competition law, because competition law turns to a large extent on unknowable facts, like will there be future innovation and under what circumstances, and unobservable facts, like what is marginal cost. And the problem of uncertainty is exacerbated by attributes of the digital platforms, new technology that is not well understood. Much of the conduct is not observable with algorithms and machine learning, the economic complexity of the business models, and so on. So I think the challenge ultimately is how to retain sound economically competition law without having to choose between defaulting to inaction because of uncertainty and intervening without a sound basis for doing so. And I think that will require a combination of the following: new analytical tools, a better understanding of multi-sided markets and barter or zero monetary price markets, new legal tools such as presumptions and perhaps shifting the burden of proof under certain circumstances with, for example, acquisitions of nascent competitors, rules that will enable probabilistically sound decisions under uncertainty, and a judiciary that understands competition law much better than many, at least the U.S. judges do today, maybe as suggested in the Stigler report, some kind of specialized tribunals or specialized judges. So I think those are the front lines of concern. I wanted to just add one thing in response to Amelia talking about under-enforcement. I think there probably has been under-enforcement in competition law in general, in the U.S. at least, but I don't think you can ascertain that simply by looking at an existing dominant platform and saying, oh gee, we didn't intervene soon enough, or it's powerful, or it's already tipped, maybe we can't fix it. Those are true costs of the imperfections of competition enforcement, but the measure of whether competition law is under-enforcing must also take into account the deterrent effect of competition law on conduct that we didn't see because it was deterred. To me, the real success of competition law, after all, the cases are a small portion of business decisions that are influenced by the law, lies in the multitude of anti-competitive actions that are not taken by firms because they're deterred by the fear of fines and treble damages in the United States, and the multitude of pro-competitive actions that were taken because they were not over-deterred by an overly intrusive competition law. And I think we have to consider those effects when we determine the extent to which we have under-enforcement that requires recalibration or change to our competition law.
Jacques, you already alluded to some of the challenges, I think the incentives to innovate, how to ensure that we continue enjoying the benefits of digitalization, the complexity of digital markets. Any reaction to what you've heard or what you've heard from the videos?
Yeah, so there's so many things to say, it's a little bit scary. I don't feel. So yesterday, I was listening to a podcast where Tim Hartford said that panels were always boring because people didn't disagree. So, Doug, I disagree with you. I don't think that calls for better economics, better understanding, and so on are very useful. There are lots of things we don't understand. I enjoy doing research, but but it was going to take 20 years. Competition policy was basically competition law was basically designed for a world in which competition was, we thought of a somewhat natural state of things, and we were scared that some people, by illegal means, either collusion or a huge amount of other practices, would prevent competition from happening, and competition law was the cop who prevented people from preventing competition. Here we live in a world in which we don't think that competition is the normal state of affairs. So we are in a very, very different world, and we are not going to have a good understanding of the whole system in the next 20 years. So I think we need to accept the fact that we have to act under great uncertainty about what's the proper way to proceed. So in our report, we tried to kind of cut a little bit through this by saying, for instance, take something like multi-homing. Okay, we know that multi-homing can be good or can be bad for competition. Any beginning assistant professor can make you models going one way or the other. Okay, so calling, we need to have a very good economic analysis to know whether a firm which is preventing multi-homing is doing something which should be illegal, and we should go and look at the effect on consumer welfare. Nobody knows how to do that. It's just too difficult. So what we propose in our report is to say, look, a competition authority, if it sees a practice, has to prove that it prevents multi-homing, which is something which generally is not too difficult. And if it prevents multi-homing, then it's up to the firm to show why, in this case, multi-homing was pro-competitive. So I know that by doing something like this, there will be some false positive, and some people are going to be penalized when they shouldn't be. But I think we've got to accept this, and we can't just say, no, we need to study more, because we're never going to do more. Another example, if you go on hotel reservation sites, you get rankings. Okay? If you go and you click very far in the bottom and you look at 3 pages and so on, you'll see that the ranking is determined by lots of factors, including how much was paid by the hotels in order to get to the top of the ranking. No consumer knows that. Okay? This is clearly something which we can discuss. I'm sure that if pay me enough and I will find you a good theory about why kind of hiding those things is good. But we know that there's 99% probability that it's a bad thing, and why don't we just use consumer protection law then to say, look, transparencies of platform, and if you are ranking, you should make at least a decent effort to explain how your ranking is being done. But so I think there are things which I think we need to act faster. Now I know it's very difficult, because I know that consumer law has this the propaganda about competition. The propaganda about competition law is that it's wonderful because it's very flexible and it adapts, and it's we do this case by case and so on. But we know that this right now, it's preventing competition law from changing fast enough, and that the precedents sometimes are a real burden. And so we've got to, and on this, I think that Europe in particular has a benefit over the administrative aspect of European competition practice, which is sometimes a real problem. In this case, is a benefit because it makes it more flexible. And I'll stop here, even though there are about 1 million other things to be said.
Well, I want to react. Well, I mean, I guess yes. No, I guess yes. I don't disagree really with what Jacques said after he stopped saying he disagreed with me in the following sense. I think saying that if you identify a practice, like a kind of conduct that is preventing multi-homing, you've probably identified a harm to competition, and now it's up to the defendant to justify it by pointing to an efficiency. That is actually black-letter U.S. antitrust law. So that doesn't bother me. I certainly did not mean to say, when I said we should develop better analytical tools, that antitrust laws should stop trying to enforce until we've reached a kind of, state of complete knowledge, but simply that even in order to identify the effect of conduct on multi-homing, to identify the effect of zero-price markets and the like, and certainly to know a lot more about multi-sided platforms, we need more tools, just as economic tools in vertical mergers and horizontal mergers and the like have done so much to enhance the accuracy of competition decisions. So I don't disagree with the specifics of what you said, but by the same token, I don't think we should simply jump in because we have a problem until we know what we're doing.
Before we get a couple of questions maybe from the floor, I think we should address maybe the other side of the coin. So there are challenges, many of them, but all of your reports have identified solutions, proposed ideas, a wide range of ideas. So we did ask the four heads of agency the question, if they had a magic wand, what would they do? What would they change in the current enforcement or merger control system? What tools would they like to have to address the challenges that they have listed in the first question? So let's hear from them, and then maybe have a quick discussion and get some questions or reaction from the floor.
I do believe that the toolkit that we have in the instruments in general are sufficient to deal with cases in the digital economy. But in the very end, it's the courts who are going to tell us if the toolkit is really the one that we need. Our experience in this respect is somewhat mixed. We have had very successful cases in the digital economy. Think of the wide MFN clauses with regard to hotel portals. Think of the two cases that we have had against Amazon with regard, again, to price parity clauses, with regard to the terms and conditions that Amazon is imposing on the dealers on the Amazon marketplace. And think of our successful abuse control case against CTS Eventim, a very famous German online ticketing service. But multi-sided markets, of course, pose difficult questions. And we have pending cases before the court with regard to booking here on the narrow MFN clause with regard to our Facebook case. And we all have to see how, in general, the courts will address these new phenomena with regard to the legal framework that we have. By the way, the German legislator also has taken the initiative and is about and has already introduced some clarifications with regard to competition law on these new digital phenomena.
I think the main change is what we've got from the government. They've given us funding for a dedicated unit with, importantly, proactive enforcement powers. So we can get information to monitor what's going on, even if at the time we're doing that, we don't have a particular contravention in mind. So proactive enforcement are now the powers we've got, and we've got the expertise. I think that's the key step. Secondly, in relation to merger law, I think it'd be helpful if it was clarified that you can take potential competitors and access to data and the amount of data into account. And thirdly, I think consumer law would be better off and would better integrate with competition law if we had better laws against unfair practices that could deal with take it or leave it agreements and things like that, which can also help improve the competitive environment.
Current U.S. antitrust laws provide the FTC with the tools necessary to address competition challenges in the digital economy. Over the years, antitrust laws have proven to be sufficiently flexible and resilient to enable enforcement against conduct that harms competition in a broad range of markets, even as the economy has evolved with technological progress. I do not expect this to change when it comes to enforcement of antitrust laws in the digital economy. That's not to say that antitrust enforcement in digital markets is easy. These markets raise difficult economic and legal questions that pose special challenges for enforcers. To meet these challenges, we have recently launched our Technology Enforcement Division that focuses on antitrust enforcement in digital markets. Having competition, consumer protection, and data privacy under one roof also allows us to use cross-disciplinary expertise to understand competitive concerns in the high-tech sector and promote competition in digital markets.
Until they invent a crystal ball for competition enforcers, I would like greater visibility into the but-for world when evaluating consummated transactions in digital markets. This would be especially helpful in the context of nascent competitor acquisitions. We sometimes hear that an acquired firm would not have grown into the entity it is today without the investment, know-how, or strategic management of the acquirer, an argument that requires challenging qualitative and quantitative assessments. Ordinarily, agency staff might investigate how actual or potential competitors reacted to the nascent firm to gauge its competitive threat to the acquirer. These assessments can be tricky. Without presumptions or safe harbors in this context, we have to be careful not to destroy the investments that incentivized their development and entry in the first place. Nor can we allow digital monopolies to build walls or functional moats around their core business to the detriment of competition and consumers.
So I would say that, unsurprisingly, the agencies think that the legal framework is fit for purpose. They all seem to agree that they have the tools in general to deal with those concerns, although I think some jurisdictions have changed the legislation, have started sort of thinking about reforms. I think Andreas alluded to the reforms in Germany. It seemed to me that they are all open to what I would call sort of institutional adjustments, so creating teams, dedicated units that can focus on the concerns that the digital economy has brought to the agency. And maybe something that also came up in the discussion already, maybe better integration between competition law, competition enforcement, and other policy areas, consumer law, data privacy. So all of you have worked on reports which came up with a lot of suggestions for governments, for agencies. So if you had the magic wand, which one of those suggestions would you focus on, or you think government should focus on, which has the highest chance of helping agencies? Maybe I can start with Jacques and the special advisors report to Commissioner Vestager.
Well, I thought that Andreas Mann's statement was not quite what you said. He said, we have the tools, but I'm afraid that the courts don't understand competition law as well as we do. So it's not clear that indeed that competition law is appropriate if the courts don't understand it. So I think the statement was a little bit more ambiguous than you put it. I'm happy that I don't have a magic wand because I don't know what I would ask for. Just 2 points. One point is I think this question of information is really very, very important. And again, in standard markets, you know, we've developed lots of ways by which we can, you know, see prices, see volumes, and so on. With very concentrated industries, it's much, much harder to observe what's happening. So we've got, it's very, very, it's impossible basically for an outsider to know exactly how, in which way, if, and in which way, if it is, organic search on Google is influenced by advertising, and that's something which would, I think, be really, really important in terms of enforcement, in terms of developing the theories of consumer harm. And in order to get the data, you need to be able to go inside the machine. And so I think there's really more thinking should be done about how can we get better information about the functioning some of the big platforms, and I think the Australian was mentioning this. But it's a very tricky system because you don't want. I mean, of course, there is IP which you need to respect and so on. So I don't think. The second point I'd like to mention is that, and which was mentioned here, is that, one of the striking aspects, it seems to me, about what's happened in the last 20 years is that we've had the rise of private marketplace. One of the things that the internet has done is that markets, which was this kind of abstraction invented by economists, have become real things and which are owned by private parties. So one of the things we don't understand is how does a world in which marketplaces are privatized function. We don't know that very well. But I think that one thing I would like is for us to have rules for what are the responsibility of private marketplaces. Are they decentralized? And in our report, what we argue is that in some sense, they are becoming decentralized regulators. I mean, they are taking on, they are organizing part of our markets, and there is no reason why competition authorities should spend all this time making sure that markets are competitive and that private marketplaces would not have the same requirement. And in particular, one way in which we know that we can make lots of money is by selling monopoly. Actually, that's the easiest way in the world to make money, is to sell monopoly. And we should make sure, I think, we should have, what I would like, ask my magic wand is to have some kind of intelligent regulation to ensure that private marketplaces don't have, to have some to know how to prevent private marketplaces from creating competition problem on the platforms itself. I'm not sure I was very clear, but I hope you've understood what I said, even though I wasn't clear.
We can ask Doug to. You've been sort of in one of the large tech companies, global companies. You've been in an agency. So, what do you think authorities should do to better enforce competition in digital markets?
Well, the views I express here are not necessarily those of the Intel Corporation. Conceptually, I agree with the officials who said that the toolkit of competition law are adequate. That is, but that's true conceptually. There are a lot of real problems in their application. My prescription for changes are quite different for the EU on the one hand and the US on the other. Let me start with the EU, and I have a suspicion Jacques won't agree with probably anything I'm about to say. I think the problem in the EU, or at least a problem that is really important and shouldn't be overlooked, is the lack of an adequate fact-finding process and insufficient discipline of the competition agency. As to the first, defendants have no right of discovery from third parties and no right of confrontation of adverse witnesses. And as a result, the decisions are ex parte and often, I think, ill-informed. As to the second, agency discipline, there's no judicial review before remedies are implemented, and there's excessively deferential review thereafter. Now, my experience, not at Intel, but when I was in the Justice Department, is that the discipline of having to ask yourself, not only do we think this conduct is anti-competitive, but how are we going to prove this to an independent tribunal, is an enormously valuable discipline that makes you think a lot harder and think a lot more clearly. And it's my observation that, frankly, DG Comp is not held to that same kind of discipline at the front end, and that leads sometimes to decisions that are, frankly, less coherent, less well thought out than I think they should be. In effect, a bias toward false positives. I think the EU's procedures should be addressed to fix that. In the U.S., the problem, I think, is the opposite. I do think there are too many false negatives in the U.S. in general and perhaps with the platforms. There's an unexamined and overstated notion that false positives are worse than false negatives, and that has driven a lot of antitrust doctrine in the U.S. that tilt very much toward false negatives to guard against false positives. And some of our doctrine, unilateral refusals to deal, predatory pricing in particular, explicitly acknowledge that they're going to permit some false negatives in order to avoid a greater problem of false positives that they think would happen if the law were different from that. Those views, by the way, are not crazy, but they indicate a judgment. So I think in the United States we need to recalibrate our relative risk tolerance for false negatives and false positives. We need to adopt new doctrines and procedures and perhaps presumptions, shifting the burden of proof and the like to embody that new balance. We need to take into account, if we can find a suitably rigorous way to do it, magnitudes of harm from enforcement errors as well as just likelihoods. In other words, the question shouldn't be, is it more likely than not that this conduct will be anti-competitive? One way of thinking of that is imagine a distribution of possible outcomes from intervention. Our law, and I think it's true probably elsewhere as well, basically looks at the median, what's more likely than not. Conceptually, theoretically, be better off looking at the mean. So if you had an unlikely but catastrophic bad outcome, for example, you'd want to take that into account. And then finally, we want to educate judges to better understand the law. Some of our judges, I think, still think that Bork's classic 1978 book was the final word on economic analysis. And if necessary, I think the law might need to be simplified a little bit to make it more accessible to judges.
Amelia, the Firma report is now, what, a year old, and it triggered a lot of discussions on some of the suggestions in the report itself in the UK.
Yeah, I again don't think you're going to get a huge disagreement, although I'm not sure I agree that there's too many false positives in Europe. Even I think the outcomes are good, even if maybe the process you could question. I would actually really agree with the point made by Rod Sims about the benefit of being able to get in and get information even when you haven't got a really clear contravention in mind. That's really similar to in the UK, our market study powers, and I think we've proven time after time, and the digital advertising study I mentioned earlier is a classic case in point, that actually it's only when you start going in and asking difficult questions and really trying to understand how a market works that you work out whether there are problems in how that market works. And sometimes we always go in with the CMA always goes in with an open mind, and sometimes it comes out saying, yeah, there wasn't a problem there, and sometimes problems emerge that they had never dreamed of, and it really, really is crucial to be able to do that. And I think it's great that Australia now has stronger powers there. On this tricky court issue, I mean, I do think recalibration is important, but you can only do that if you have the courts on board one way or another. There are a variety of ways that you can do that. One of the recommendations of the Furman report was to rewrite guidance on the merger assessment to be clearer how merger assessment should be done in digital mergers, to be clearer about, for example, how data issues should be addressed. And the hope then was that if the CMA abided by its own guidance, then that would be respected by courts. So that's one way you can go about it. If that's not going to work, sometimes you actually need legislation to provide very clear clarity for both the authorities and courts, and actually for industry as well, on how issues are going to be addressed. And clearly some of that has happened in Germany, and that is a potential route. Another option, which goes to this point about do you go for the median or the mean that Doug mentioned. I mentioned earlier that the Furman report recommended changing the merger test. Actually, it was in exactly the way that you've just described. Essentially, we have, in the UK at least, a test that is more likely than not. But we noted that in a lot of these markets, what we end up with is a huge amount of uncertainty, but some probability, but may not be 50% probability, of a very immense amount of harm, essentially taking out the only potential competitor in a market which will otherwise be monopolised, and that ought to be a theory of harm and a set of evidence that we could intervene against, but it's hard under the more likely than not threshold, and therefore we recommended something we called the balance of harms approach, but essentially it's like an expected value economist, how economists actually model merger analysis anyway when they write academic papers. They didn't actually realise that wasn't how it was done for the most part. So it makes a lot of sense. There is issues around implementability that I think are serious issues and need thinking through, but from an economics perspective, it does make a lot of sense, I think. And then I think finally, of course, there is a debate about exactly what the appeal standard is and exactly what the process is. I'm afraid in the European camp of preferring administrative rather than procedural approaches here for exactly the reason that I think you can veer towards a huge amount of false negatives in a procedural approach, despite the fact you end up with very good process. So.
Thank you all, and I think maybe that's a good time to...
Can I just add
of course.
Quick, first, to say that we also have in our report a discussion along the same lines about the error cost framework. So I think there's a general consensus on this. And secondly, I wanted to say that I disagree with Doug, that I would disagree when he said that I would disagree with everything he would say. I was in agreement not with everything, but with quite a bit of what you said.
So maybe time for a question or two from the floor. While you think about a possible question, don't forget to answer the question we have for you. So do you think we should have more enforcement, more regulation, or a hands-off approach by government? Any question that you would like to ask our panelists or reaction to what you've heard so far? Okay, I see 2 hands up. If you can introduce yourself and be very, very succinct so that we can get to the question immediately. Thanks.
Hello, Eurasian Economic Commission. I have a question to Amelia. In your speech, you mentioned the code of conduct for different platforms that are elaborated or in the process of elaboration in your country. Can you just tell us a little bit more? Is it at what stage is the process, or is it only an idea for the moment?
Maybe let's take another question and then we can answer them. There was another hand somewhere here, I thought. Yeah.
Hello. Hello, Fernando Herrera. I'm professor at University Polytechnic of Madrid. I just wanted to come back to the issue that was mentioned by Jacques Crémer at the beginning of his speech. It was about the innovation in the European Union. It has something you haven't dealt with during the rest of the speech, and I wanted to come back for that. The question is quite simple. If you were an entrepreneur, if there is an entrepreneur in the audience and is hearing you just talking about antitrust and antitrust implementation in Europe, what do you think? Would he invest in Europe, or would he rather go to other place?
Maybe a third question, and then we move back to the panelists.
Hi, my name is Rajesh Sharma. I'm a board member of an Italian company, which is in artificial intelligence. And just to share one observation and then a question on it, I think there are 4 things which distinguishes digitalization. One is it takes away the traditional intermediaries. It increases the velocity of the transactions. And the third thing it does is that it increases the volume of the activity that could be done. And the fourth thing it does, which is very powerful, is that it creates a bit of a deflationary effect on the industry which it impacts. Now, if these are the 4 characteristics which traditionally determine the impact of digitalization, do you believe that the competition laws should begin to focus a lot on how the end consumers or the end recipients of those services need to react and to be informed? Because if you can bring privacy laws and consumer laws together, I think there is a way to address the competition issues. Because if I, as an end customer, become aware of what I'm consuming, why I'm consuming, and at what price point I need to consume, then it builds a self-directing mechanism to a large extent, not always, but to a large extent. So my question is there a way to bring those aspects into the competition law definition? Thank you.
Okay, so back to the podium here. So a question on code of conducts, innovation, and then this last question about how we bring consumers and consumer perspective into what agencies do. I don't know if Amelia, you want to take the first question maybe?
Okay, yeah, so as I said, the UK government hasn't said anything public yet, but the CMA has published this interim report on digital advertising, and in that it doesn't say what codes of conduct would look like or even what principles would definitely be, but it does float some more detailed ideas than we did in the Furman report. So it suggests that the overarching principles, this is having looked at digital advertising, but my hunch is these could actually work more generally, would be first a principle of fair trading, secondly a principle of open choices, and third a principle of trust and transparency. And some of those fit with some of the things about running a fair, open marketplace that Jacques was talking about. Some of them fit with avoiding anti-competitive self-preferencing. Some of them are literally just about making sure, we heard earlier about the importance of consumers just knowing what's going on and being given clear information to be able to make reasonable choices, not just consumers, actually all platform users. So I think those are good overarching principles, and then what the CMA does is drill down to what that might mean, in particular in the digital advertising space, which starts to get closer to what codes of conduct might look like. But it's really quite early days, but that is, I think, probably, at least in the UK, the state of the art at the moment. Just going on this other question about the four distinct characteristics of AI and digital, which I think is really interesting. You raised a particularly interesting issue, which is the role of privacy regulation and how that interacts with competition regulation. And again, there are some quite complex interactions, and the CMA report into digital advertising does look at how the GDPR is playing into the competition in the ad tech stack, and how actually the sharing of information that was happening pre-GDPR may arguably have been more pro-competitive, although potentially problematic for privacy relative to what's happening post-GDPR. So there might be a tension between competition and GDPR that I think we need to take very seriously and think through how we get the right balance between privacy. I mean, essentially, in all of this, there is a hugely difficult balance to be struck between competition and privacy.
So I'll just take the question on innovation, although the others were interesting. But if I were an entrepreneur, it's not really a very important issue, but it's clear that if you look at the number of European born and educated entrepreneurs who have created firms in the US, and the number of American-born and educated entrepreneurs who've created firms in Europe, you'd see the difference clearly. If you followed my wonderful Twitter feed, I'm doing abuse of dominant position here by advertising. You know, for instance, Snowflake, which is one of the kind of leading unicorns right now who does cloud things, out of their three top executives, have two who have been raised, born, educated, including college or PhD in Europe, and have become entrepreneurs in the US. By the way, you see the same thing if you look at Nobel Prizes. You look at the number of people who are based in the US and have a Nobel Prize and have been raised somewhere else in the world, you get a huge proportion. We do have some Nobel Prizes in Europe. Very few of them have been born outside of the country in which they are working. So yes, there is a big problem of innovation in Europe, and I think there are some, those are not kind of formal statistics, but there is some evidence to back it up.
I just add a couple of thoughts. Obviously, the innovation question, by the way, I think all three of the topics raised by the questions, innovation, the kind of code of conduct regulation, and the consumer choice issue, they're all interrelated. Obviously, innovation is critically important. All the economic scholarship, as I understand it, it demonstrates that it's much more important than avoiding a static allocative inefficiency. So it has to be safeguarded. That leads me to believe that the critical role for any kind of special intervention in the digital platforms should focus on the issue of entry barriers, not avoiding a static deadweight loss. That's kind of the first thought. And that takes you to the issue of what about a code of conduct? Well, I think it's always dangerous to have regulation because of the risks of obsolescence, ossification, capture. You're all familiar with all of those problems. I think one conceptual way to think about it is to say, is a code of conduct going to define, for example, kinds of conduct manipulating behavioral biases that it deems to be anti-competitive and prohibits on the one hand, which is, it seems to me, is a potentially very fruitful approach. Or on the other hand, is it going to go into the category of prescribing conduct that will make markets work better? And that takes you, it seems to me, into a dangerous area of government interfering with effective competition. And then finally, on the issue of privacy, yes, there's clearly a tension between privacy and competition, particularly if you focus on entry barriers and you say, well, gee, the way to lower entry barriers is to increase access of new firms to the data assembled by the incumbent firms, because that obviously raises a privacy question. And there is evidence, as I understand it, that GDPR has had, as Amelia said, an unfortunate impact on competition in some markets. And it can do so in two ways, of course, by impeding the flow of information and thus increasing entry barriers, and by imposing regulatory burdens, even if intended to facilitate competition, that wind up being more burdensome proportionally to small firms than the big firms, and thereby actually giving a competitive advantage to incumbent firms. So to the extent our focus is on innovation, which is where I think it should be, I think we should in general be very cautious about prescriptive regulation.
And that leads me to the last area that we had picked for discussion, this issue, this question of regulation. So going beyond enforcement powers, adjusting enforcement powers, is there a need to introduce ex-ante regulation to improve competition in digital markets? Let's hear from our virtual panelists, and then maybe we can wrap up the discussion here in the room.
We might need some regulation, yes, but the crucial question is which kind of regulation and regulation in which sense. I firmly believe what we do not need is some kind of a sector-specific regulation that we see in some branches, not only in Germany, but in Europe and worldwide. What we might need is some regulation that has a spirit that is similar to competition law. And in fact, the German legislator considers such a kind of regulation. The idea is that the Bundeskartellamt can issue an order assessing that a certain company is of paramount significance for competition beyond the scope of one market. And on this basis, we then can prohibit certain kind of behavior, like, for example, self-preference, like envelopment strategies, or like establishing barriers to entry through use of data or hindering portability or interoperability. And this is very important, even on markets where this company is not yet dominant. The underlying idea, I think, is not unique. This is something that is discussed in many other countries, like the Netherlands, like the UK, or like Australia, and I hope we find some kind of provisions here that strike the right balance between competition law on the one side and regulation, very similar to competition law on the other side.
At the ACCC, we do ex-ante regulation of things like telecommunications and transport and other sectors, and we're always very wary of it. If you can avoid ex-ante regulation, rely on competition, that's much the better way. I have heard people talk about ex-ante regulation controlling self-preferencing and things like that. I'd like to think we can deal with that in Australia through dealing with it as it happens. And I guess that leads to my dominant point, which is I think the most effective form of ex-ante regulation is what we're trying to set up in Australia, which is a dedicated unit, proactive enforcement, where also you're providing regular monitoring reports to government and the community, and there's nothing like that transparency to both influence behaviour and inform government about whether any regulation is actually needed.
Even if regulation of the digital economy could keep pace with the rapid rate of innovation in this sector, I would still prefer law enforcement over regulation. To quote former Senator Orrin Hatch, the legendary chairman of the U.S. Senate Judiciary Committee, quote, "Vigilant and effective antitrust enforcement today is preferable to the heavy hand of government regulation of the internet tomorrow," end quote. We know this firsthand. After all, the DOJ's successful case against Microsoft arguably paved the way for companies like Google, Yahoo, and Apple to enter the market with their own desktop and mobile products. Microsoft is no outlier. As the great biographer Ron Chernow explained in his account of the Standard Oil monopoly, quote, "The antitrust suit against Standard Oil tested whether the American legal system could cope with the new agglomerations of wealth and curb their excesses. The paradoxical lesson learned was that government enforcement was sometimes necessary to ensure unfettered competition."
Appropriate regulation can help develop a marketplace in which competition can thrive. The FTC therefore supports properly tailored regulation to address legitimate policy objectives, such as data privacy and consumer protection. Based on our experience, I don't agree with those who call for a digital regulator and the creation of a new regulatory scheme dedicated to digital platforms. In my view, there are many drawbacks to creating a regulatory scheme of that type. For example, it is hard to imagine a one-size-fits-all set of regulations that would address the different business models and concerns raised by the varying types of platforms. Moreover, such regulations would require constant updating to account for changes in the market. I am also concerned about potential unintended consequences of a regulation on incentives to innovate, including by inhibiting timely commercialization of new products and services because of required regulatory approvals. I believe antitrust enforcement is capable of protecting competition in digital markets and is preferable to ex-ante regulation.
Okay, so regulate or not to regulate, that is clearly the question, and it's the last question of the day. Maybe I can ask our panelists here to react to the question and maybe draw some conclusions, so because we are at the end of the panel, and maybe one input is what you think about this question of balance between enforcement and regulation, ex-ante regulation. So if we can put up maybe the results from the poll on screen, we can use it as a sort of an input for some final comments. That maybe I can start with you this time about this issue about ex-ante regulation. So if you read this correctly, 32%, almost 33% thinks that there should be more vigorous enforcement of competition law. 57% thinks that government should take a more active regulatory approach to address concerns in the digital, concerns from digitalization, and only 14% thinks that government should stay out of markets and let the market shape the future of competition.
Well, it doesn't surprise me to know that I might not be in the majority. Look, the premise of competition law, as I understand it, is that competition is a better discipline for markets than the assertion of power by powerful entities, whether they be private firms or the government. And I think that's generally correct, particularly when we're concerned about innovation, which by its very nature involves conceiving of something not previously understood, and therefore perhaps impeded by a regulator who did not anticipate it. So I think that competition law in general should be based on the application of sound principles to the fact of particular cases, rather than the application of general rules of conduct, regardless of the particular facts. The problems with regulation, I guess I've mentioned most of them, but certainly in addition to the ones I've already mentioned, are a potential myopia because of information asymmetries. The regulator, knows less than the regulated. Mission creep, and of course, capture. That doesn't mean, however, that there's no role for sectoral specific rules. Now, the Stigler report, unlike the EU and UK reports, did not recommend establishment of a sectoral regulator. But
we didn't recommend one. We didn't discuss the issue.
Didn't discuss the issue? I thought you, well, okay.
No,
right,
not,
okay.
Not in the EU report.
Okay.
It was the Furman
Well,
report.
the Furman
Although I
report.
actually did think the
Certainly
Stigler report did as well, so I'm learning something.
Okay. Stigler report said a regulator should be considered, and it was very, very imprecise about what that regulator might be. Here's what I think would be the case in the U.S. at least for sector-specific regulation. In the U.S., the antitrust laws are laws of general application. They apply basically to all industries with a couple of exceptions. More than that, they're widely enforced by 52 government agencies, 50 states and 2 federal agencies, and by any private entity that suffers injury as a result of an antitrust violation, who can bring a lawsuit in any of hundreds of courts throughout the country. So antitrust laws and rules in the United States are appropriately tempered to take into account the multiplicity of potential plaintiffs, the potential for abuse, and the need to have rules that are accessible to and enforceable by hundreds of generalist courts around the country. One could imagine an argument that would say that the competition problems in with digital platforms are sufficiently unique and sufficiently serious and sufficiently important that we need special rules for those platforms, not rules that are encumbered by the inhibitions attributable to other aspects of the U.S. general antitrust law. So one might imagine, it seems to me, a sectoral regulator with a very narrow mandate, a mandate to enforce competition law, although a specific law just for digital platforms, but a law that is optimized for rules for that sector. For example, as I suggested earlier, adjusting perhaps the rules applicable to unilateral refusals to deal in order to make data sharing and interoperability more accessible, perhaps changes in rules for predatory pricing and maybe some burden of proof and presumptions and the like. Conceivably also some narrow prescriptive regulation with respect to interoperability and data sharing. But basically it seems to me that the case for regulation, at least in the US, would point toward a sector-specific competition law in the nature of law enforcement rather than prescriptive regulation.
So I think it's really interesting because a lot, as Andreas says, a lot comes down to what you mean by regulation. And actually, in Germany, essentially, they have taken the Furman proposals and gone further, but they haven't really called it regulation. They've called it a kind of extension of competition policy. So, and it's being done by the Bundeskartellamt. So whether it's greater sector-specific regulatory tools for competition agencies or a regulator, in a way, the question is what extra needs to be done. I do think that there's some very good ideas in the Stigler report, which I read with great interest, and I do think they should be considered. The thing that I would just add, I mean, I think you know my views general on this question, but the thing that I would add is I think one huge benefit of competition law, and this is particularly pertinent in this room, is that there's a broad similarity of approach across jurisdictions. There are differences, and we have a lot of discussion about those differences, but there's also a very broad consistency of framework as well. And I think, A, it would be really good to preserve this, but B, it would be good to extend this into regulation if we are going to be taking regulation into digital platforms, because these are global companies, these are global issues, and it actually is only fair on the companies to do this on as transnational a basis as we possibly can. So the more that we can get some sort of agreement across people like the people in this room about what needs to be what needs to be done, and then some sort of coordinated action, I think that's incredibly valuable and important.
Okay, so first, I jumped when it was said that we recommended regulation when we didn't, and that's just because we didn't discuss it. We ran out of time, and so it's not that we were for or against, we just didn't speak about it. Now, my own personal thinking about it is, I think it's a great idea to try it in Britain. It's interesting that it's not it's an insult to other countries. But in your report you stress that it's a pro-competitive regulator. There are some other countries, some of which have very good food and very good wine and very good cheese, in which having a pro-competitive regulator would be a more risky endeavor, and I'm not sure that the regulatory kind of culture would be good in that direction. So I think you've got to be very careful about, the specific, Doug was making this point, the specific institutional feature. There's another point, though, I want to mention, which is linked to what I was saying in my preliminary remarks about the fact that digitalization is going all across the thing. And we didn't take the example of whether or not we should consider drivers for Uber, Lyft, Captain, and so on as employees. Okay? This is a labor law problem. But it clearly has implications for competition, because if they are considered as employees, it's going to be very hard for them to multi-home between several employers, and hence it's going to be much harder to enter in this market. Okay? This is not something which a digital regulator can handle, because it's a link with with a labor law. And so I think there are quite a number of issues which are very transversal this way, and I think we need a way to tackle those. One more minute. So I was very excited when Commissioner Vestager, sorry, 2 minutes with my coughing, was put in charge of a European Fit for the Digital Age, because that clearly gives, something which you look at the whole range of regulations and not only the digital regulations. And I think we should. So the rest of the mission letter which she has is more disappointing than the title she got. But I think we really need to think of some of regulations which are not of the way in which we're going to adapt not only the digital regulation but the whole society to this new age.
Well, thank you very much, and unfortunately I have to bring this exciting panel and discussion to a close. Please join me in thanking Doug, Amelia, and Jacques for a wonderful conversation. They'll stay around certainly for the coffee break, which is waiting for you outside, and it's been kindly offered by Power, our media sponsors. It's a little bit shorter than usual, so please do what was planned in the agenda. Try to be back at noon so that we can be back on track on the agenda. The next panel will be on FinTech, Big Tech, and competition. Thank you very much.